In the previous section, we learned that escrow officers serve as neutral fiduciaries whose primary duty is to safeguard funds, documents, and instructions until all contractual conditions are met. This neutrality forms the ethical and legal cornerstone of the escrow process, ensuring that every participant, buyer, seller, lender, and broker can rely on the integrity of the transaction. Building on that foundation, this section explores the concept of escrow neutrality, the obligation to disclose conflicts of interest, and the statutory prohibitions against accepting compensation that could compromise impartiality. The principle of escrow neutrality. Neutrality in escrow means that the escrow officer must treat all parties to the transaction with complete impartiality and fairness. They cannot favor the interests of one party over another, nor can they allow outside relationships or financial incentives to influence their judgment. This principle protects the integrity of the closing process and ensures that the transaction proceeds based solely on the written instructions and applicable law. The Arizona Department of Financial Institutions, AZDFI, which licenses and regulates escrow companies under ARS, BRGRV 6 841 at SEQ, requires every escrow agent to act with integrity, competence, and neutrality. Escrow officers are not advocates. They are custodians of trust. Their job is to carry out the terms of the escrow agreement precisely as written, verifying that conditions have been satisfied before releasing funds or documents. Any deviation from those instructions, or any indication of bias, could result in disciplinary action, loss of license, or civil liability. Conflict of interest disclosures. A conflict of interest arises when an escrow officer or company has a personal, financial, or professional relationship that could influence, or appear to influence, the handling of escrow funds or documents. Arizona law requires that all actual or potential conflicts be disclosed to all parties in writing before or during the transaction. For example, if an escrow company is affiliated with a real estate brokerage, mortgage lender, or title insurer that stands to profit from the transaction, that relationship must be clearly disclosed to all participants. Consider this example. A title company owns an affiliated escrow division that handles transactions for its partner brokerage. The buyer and seller must be informed of this affiliation before escrow is opened, allowing them to make an informed decision about whether to proceed. This requirement reflects Arizona's broader consumer protection laws and the Federal Real Estate Settlement Procedures Act, RESPA, which prohibits undisclosed financial relationships that may limit consumer choice or inflate costs. Disclosure is not merely a formality, it is a safeguard. If an escrow officer fails to disclose a conflict, even unintentionally, they may lose their license under ARS, paragraph 6, 846, or face civil liability if the conflict results in financial harm to a party. Transparency allows all parties to evaluate whether the escrow company can act impartially and fulfills the officer's fiduciary obligation of loyalty and honesty. Prohibited compensation and inducements. To preserve neutrality, Arizona law strictly prohibits escrow officers from accepting or offering compensation, gifts, or incentives that could influence the selection of an escrow company or the handling of an account. These prohibitions are codified both at the state level and under RESPA Section 8, which bans kickbacks, referral fees, and unearned compensation in connection with settlement services. For instance, an escrow officer may not offer a real estate agent a gift card or referral payment for directing clients to their company. Similarly, a broker or loan officer may not receive a fee or reward for steering a client toward a specific escrow or title provider. Even small, seemingly harmless perks, like free lunches, entertainment, or advertising support, can be considered improper inducements if offered with the intent to influence business decisions. Violations of these rules can result in severe penalties. Under RESPA, violators can face fines up to $10,000 per occurrence and imprisonment for up to 1 year. At the state level, AZDFI can impose fines, suspend licenses, or revoke operating authority. Escrow neutrality, therefore, is not only an ethical standard, it is a legal obligation designed to maintain fairness and public confidence in Arizona's real estate system. Escrow officer impartiality in practice. Neutrality extends beyond financial relationships. It also includes the way escrow officers handle communications and decisions. For example, if a buyer and seller disagree over a repair credit or timing issue, the escrow officer cannot make a unilateral decision about who is right. Instead, they must hold funds in escrow until both parties agree in writing or a court order resolves the dispute. Acting otherwise would constitute bias and breach of duty. A key Arizona case that demonstrates the importance of neutrality is Burcons vs. Ticor Title Insurance Co. of California, 1991. The Arizona Supreme Court held that escrow agents owe fiduciary duties of fairness, honesty, and loyalty to all parties, and that any deviation from those duties, whether by partiality, concealment, or improper communication, violates that trust. The case also affirmed that escrow officers must disclose any information known to them that could affect the transaction's integrity. Real-world application further illustrates these principles. Suppose an escrow officer handling a sale learns privately that a delay in loan funding might cause the buyer to lose their interest rate lock. The officer cannot warn the buyer in a way that disadvantages the seller or manipulate the closing timeline to favor one side. Their role is to remain neutral and act only upon the written instructions of both parties or their authorized representatives. Discussion. Why must escrow officers disclose conflicts of interest to all parties in writing? Answer. Because disclosure ensures transparency and allows parties to make informed decisions about the neutrality and reliability of the escrow process. Preserving trust and compliance with Arizona law. What is prohibited under RESPA and Arizona law regarding escrow compensation? Answer. Escrow officers and related settlement service providers are prohibited from offering or receiving any form of kickback, gift, or referral fee in exchange for business. As such, inducements compromise neutrality and violate federal and state law. What is an example of a violation of escrow neutrality? Answer. An escrow officer releasing funds early to one party without authorization or offering incentives to a broker for referrals would constitute a breach of neutrality and fiduciary duty. Review summary. Escrow neutrality is the ethical and legal foundation of the closing process. Escrow officers must act impartially, treating all parties with fairness and honesty. They are fiduciaries bound by law to disclose any actual or potential conflicts of interest in writing, and are prohibited from accepting or offering any form of compensation that might influence the transaction. Both Arizona statutes and federal laws like RESPA ensure that escrow remains a neutral and trustworthy process. The Burcons versus Ticor title case established that escrow officers must follow instructions precisely, disclose material information, and act with total integrity. Neutrality preserves confidence in Arizona's real estate system by ensuring that every transaction is completed transparently, lawfully, and without bias.